Good
afternoon. Thank you, members, for attending today's meeting, which is on the Administration of Justice and Legal Services. Since our last meeting, we have issued the following papers. First of all, LC paper CB bracket 4995/13-14. Which is a referral arising from a meeting between LegCo members and Heung councillors held on the 20th of March 2014, requesting the panel to follow up on the views expressed at the meeting regarding the recommendations made by the Law Reform Commission on adverse possession. Another paper is LC paper number CB bracket 4/123/14-15/01. Judiciary Administration's paper entitled Allowances for Jurors and Witnesses. For the first paper, on the 14th of July 2014, the Secretariat has referred to the Law Reform Commission in relation to the views expressed by a number of LegCo members and Heung concerning adverse possession. In the reply dated 31st of July 2014, the LRC has indicated that in the report published by the LRC on adverse possession, the views collected in the consultation period between 10th of December 2012 and 15th of March 2013, including those from the Heung will be incorporated. The LRC already published the report on adverse possession on 20th of October 2014 and intends to brief us on the recommendations at our regular meeting in December 2014. For the second paper, in the light of the latest review held in 2014, the JA would like to amend the following ordinances so as to enhance the allowances for jurors and witnesses, namely allowances to jurors' order, criminal procedure witnesses allowances rules, and the coroner's witnesses allowances rules, so as to provide for the latest allowance rates after the legislative proposals have been tabled and completed. For the discussion at our next meeting, please take a look of paper CB bracket 4/172/14-15/01 and CB bracket 4/118/14-15/01, and also paper CB bracket 4/172/14-15/02. The second one is a letter from Mr. Dennis Kwok, dated the 30th of October 2014, requesting to discuss the issue of recovery of costs in pro bono cases. If members do not disagree, I also agree that this should be included in our list of outstanding items for discussion, and we'll see when we have time to discuss this matter. For our panel regular meeting, it will be next held on the 22nd of December 2014 and Monday at 4:30 p.m. There will be 3 items. First of all, adverse possession from LRC. Second one also from LRC, the report on accepted offences under Schedule 3 to the Criminal Procedure Ordinance. For the third one is a proposed creation of 1 permanent post of Deputy Principal Government Counsel, DPGC, in the Civil Division of the Department of Justice. For item A, that is the first one, the administration will brief members on the report on adverse possession released by LRC on the 20th of October 2014. For item B, the administration is going to brief members on the report issued by the LRC on the 25th of February 2014 in relation to the accepted offences under Schedule 3 to the Criminal Procedure Ordinance, Cap 221. For item C, the administration would like to create a permanent post of DPGC so as to replace a supernumerary post of DPGC, which will expire on 31st of March 2015. The administration will consult us first, and then in January 2015, the matter will go to the ESC. Members, any questions or comments, suggestions? Yes. And Zhang? Yes, Madam Chair. I want to know if we are going to review the matter of PCLL. Are we going to have a meeting on that matter? Well, in the case of the PCLL, well, there was a discussion last year. We have also received submissions from law students. In fact, if you refer to item 8 on our outstanding items, you can see that it's being subsumed under the topic of legal education and training in Hong Kong. The Law Society of Hong Kong is preparing a report, and I understand that a study is being led by Judge Chen. And last year we invited the 3 law schools to come. So I would like to defer to our clerk to see if we are going to revisit this topic in 2015. That is, have a discussion with the administration as well as the judge overseeing this matter. Maybe we should also see if the 3 law schools are also interested to make submissions to us. Any other views, please? If not, then we can go into the agenda proper. So at this moment, I would like to invite the administration to join us. First of all, the first item for discussion which is about the arbitration ordinance. So, proposed amendments to the arbitration ordinance. The Bar Association? No. Just the administration will join us at the meeting for this item. Members, please take a look at the paper. Paper CB bracket 4, 172/14 to 15 bracket 03. And that's about cap 609. The administration is proposing certain amendments. Please also take a look of paper CB bracket 4, 177/14 to 15 bracket 01, which is a submission from the Hong Kong Bar Association, though the Bar Association is not attending the meeting for this item today. Well, the administration proposes to introduce legislative amendments to remove some legal uncertainties relating to the opt-in mechanism provided for domestic arbitration under Part 11 of the ordinance, and update, for the purposes of the ordinance, the list of parties to the New York Convention. The administration would like to introduce the bill to the LegCo in 2015. I would like to give the floor to Mr. Peter Wong.
Thank you, Madam Chair. We are listing the proposal in paragraph 2. We would like to remove some uncertainties relating to the arbitration ordinance. And while we're amending the law, we would like to update some information concerning the list of parties to the New York Convention so that we can better discharge our duties. The justifications are listed in para 3 to para 7. In para 3, we said that since Cap 609 came into operation on the 1st of June 2011, we have unified the arbitration regimes for domestic and international arbitration. But para 4 points out that domestic arbitration, if the parties follow Schedule 2, Sections 2 to 7 concerning the opt-in provisions, the court may be authorized to intervene. For example, some legal issues, legal matters, disputes, or filing for appeal, or serious improper behavior during the arbitration. Para 5 points out the actual operation. According to Section 100 of the Ordinance, all of the provisions in Schedule 2 to the Ordinance automatically apply to parties to 2 types of domestic arbitration agreements. This is subject to Section 102. Para 6 points out that if a party chooses the opt-in mechanism, we have received concerns from the arbitration sector. If they specify the number of arbitrators at the beginning of the arbitration, there will be one question. Will Section 2 to 7 under Schedule 2 apply? Because there are exceptions according to Section 102 bracket B concerning the disapplication of Section 100. If the parties specify that certain provisions apply or not, or if they specifically say that Section 100 or 102 do not apply. Whether these provisions apply or not are being disputed. We see that in some arbitration agreement that they specify the number of arbitrators, and this may lead to legal dispute. Because of such concerns, we have looked at all the details. We've consulted the arbitration sector and legal bodies. Our conclusion is we would like to perfect our arbitration ordinance and remove all the ambiguities. In the first quarter of next year, hopefully we can make proposals to the amendments to remove such ambiguities. Secondly, we would like to take this opportunity to make amendments to Cap 609A concerning parties to New York Convention. In Para 8, we have already listed a number of countries, including Bhutan. We would like to take this opportunity to update the parties. Thank you. Okay, we will now allow members to speak. Is anyone interested in raising a question? I have a question and I would like to declare interest. I am an arbitrator at CITEC. I have dealt with domestic arbitration cases. Mr. Wong mentioned if serious misconduct is identified, the court may intervene. We all understand that the nature of choosing arbitration is to have something that is once and for all without court intervention. Especially for commercial arbitrations, they don't want to be made open to the public to protect the reputation of the parties involved. So can you offer some clarification? When you talk about a certain number of sections, perhaps you can offer more details concerning the content of the amendments so that it is clearer to the members. When it comes to amendments, we have to discuss the proposals. So can you clarify concerning misconduct or serious misconduct? Because if either party fails to discharge its duties according to the arbitration agreement, we need to seek other ways to resolve the matter. Can you also offer more details about the New York Convention amendments? Because not every member is very familiar with this topic. Thank you, Madam Chair. Perhaps I can talk about the updating of parties to New York Convention. According to Section 90, a channel is available for us to update the list from time to time, because at the moment 150 parties are listed on the New York Convention, including China and other major jurisdictions such as the US, Canada, UK. This list indicates that if you become a party to the New York Convention, if you would like to enforce arbitration judgments, it is possible among all the 150 parties under the convention. So when there are new members joining the New York Convention, we are legally bound to update the list of parties so that the newly added members can enforce the judgments. I mentioned that one of them is Bhutan. Assuming in Bhutan one day there is an arbitration judgment delivered, it can be enforced in Hong Kong. In order to facilitate this, we need to update the list of parties. Once they are added to 609A, it will be much easier concerning putting forth evidence. Because according to Section 92, under such order, all the countries listed can provide conclusive evidence. If they do appear on the list, they will be parties to the New York Convention. So that will be very helpful for all the parties involved to prove that Bhutan is now a party to the convention. That is to respond to the second part of your question. For the first part, if we can use Schedule 2, as the Chair Lady has pointed out, the current arbitration ordinance would like to rule out, as far as possible, intervention by the court. As I've mentioned in Para 4, there are exceptions to the ordinance when in Part 11 concerning domestic arbitration. There are two scenarios. First, both parties have chosen certain provisions to apply, or second scenario, before the enactment of the ordinance, within 6 years, both parties choose to go for domestic arbitration, then automatically Schedule 2 would apply. They normally involve construction-related arbitration. In Schedule 2, the relevant provisions would mention serious misconduct to question the arbitration itself, and it is listed in Section 4 concerning what may be considered as serious misconduct. They are incidents leading to serious injustice. So it goes from 4 to A to I. For example, the arbitration has gone beyond its jurisdiction, or there is a lack of due process agreed upon by both parties, or any fraudulent act involved. The court may then intervene. But before that happens, Section 4 must apply. Why do we need to amend the law to remove uncertainties? It is because in real practice, certain provisions may have been expressed. For example, the number of arbitrators to be engaged. And then we have a question concerning whether Section 4 will apply or not. Even if both parties specify using 1 or 3 arbitrators, or any number of arbitrators, it doesn't affect them to use Schedule 2, Section 4 to 7. But these are exceptions, and both parties have to spell out their choice, or they have to specify that it is a domestic arbitration. And 101 is about subcontracting for construction cases. Section 99 is for both parties to choose which provisions are to apply. For example, Section 100 specifying that they are domestic arbitration or construction-related cases or subcontracting cases. Okay, after Mr. Wong's explanation, any follow-ups? If not, I would like to follow up because I participated in the last amendment of arbitration ordinance. Very often concerning construction cases, parties wanted to retain some local features of domestic arbitration. We would like to avoid getting the court involved so that after one of arbitration, the dispute can be resolved. And the construction sector prefers using arbitration. You have mentioned some provisions. For example, in paragraph 4, parties to an arbitration may freely select the number of arbitrators. And then they can retain sections 2 to 7 of Schedule 2 to seek assistance from court of first instance. So this is a common practice not only happening in Hong Kong in terms of a procedure of fraudulent act is involved or something has been done out of its jurisdiction. These are serious matters, but can you explain further to the panel? When we endorsed the arbitration ordinance, back then we did not talk about this. One of our major concerns at the time was when will the court intervene? Because if you choose arbitration, it is because you do not want to go through the legal process. So can you offer more explanation on this? Because you mentioned sections 2 to 7, perhaps some members don't really follow. Maybe you need to explain further. Indeed, as the chairman has said, Schedule 2 is about exceptions. Both parties are choosing lengthier provisions allowing the court to intervene. Section 4 concerns serious misconduct, and Sections 3 concerns legal matters or appeal matters. In Section 6, they are all covered by Schedule 2. As the chairlady has said, normally, if we use a unified system under case law, it is to avoid as far as possible court intervention. If the parties do not choose to opt for Schedule 2, they can uphold the spirit of New York Convention unless there are serious procedural problems or fraud is involved. Under normal circumstances, it is not possible to refuse the mandatory execution of the judgment or have it revoked. If the judgment is delivered in Hong Kong, if you want to seek to revoke the judgment by the court, that is one scenario. If it is a judgment from the mainland or international judgment coming to Hong Kong to be executed, what are the grounds for refusal of executing that judgment? According to the spirit of New York Convention, it is only possible when there are serious misconducts or fraud or violation of public policy in a narrow sense. Otherwise, normally, legal reasons cannot be provided. Schedule 2 is the exception. and they may not be as narrow as listed by the convention, but when it comes to legal matters, making an appeal, or some initial legal matters, if they choose to rely on Schedule 2, they can ask for court intervention. That will lead to a higher likelihood of court intervention. For example, for construction contracts, this may be more likely, but for other normal commercial disputes, they normally choose to avoid this to prevent court intervention. Members, any follow-up questions on this topic?
Hi.
Well, if members don't, well, we still have time for this topic, so I would like to follow up on a further question. I did take part in the work to scrutinize the amendment bill last time. Well, it is said that there was the argument as to whether Hong Kong should follow the New York Convention. The scope was very narrow. That is, the scope is really narrow if you can still opt for appeal. Now, we prefer arbitration because it's time-saving, less costly, and then there won't be the question of a huge difference concerning the resources between the two parties, and then the award can be more easily enforced. Now, in the case of the construction industry, at that time they did ask for the opportunity to be given exception or exemption. Well, we shouldn't encourage any party to think of getting exemption and exceptional treatment, because if that is the mindset, it's better for them to opt for litigation than arbitration. Well, for arbitration, it won't just involve arbitrators with a legal background. In Hong Kong, it seems that we are the exceptional case. It seems that we have opened up a gap, and it appears that we are having this exceptional arrangements. If we are to promote arbitration, would you agree with me that we should not encourage this sort of exceptions? For arbitrations, I think it's better in the case that the two parties to a contract have very different financial positions. Yes, thank you, Madam Chair. We try our best to adhere to the New York Convention model. We should try to avoid invoking the exceptions in Schedule 2. And that's why we say that for Schedule 2, it should be an exceptional case and it should be a limited one. For Cap 341, we have something similar. What we are doing is to keep what was originally there, and would like to respond to the requests of the construction industry. Now, the two parties under Section 99 may choose the application of specific sections, but then for Section 100, it says as to how Schedule 2 would apply to the domestic arbitration. That is, the arbitration contracts already signed before the commencement of the ordinance or within 6 years of the commencement of the ordinance. In other words, automatic application would only happen between June 2011 and June 2017. So it is time limited and it must have the consent of both parties. When we promote the use of arbitration, we try to have the New York Convention being adhered to as much as possible so that there will be a one-off decision and then we can avoid having a very lengthy process. Thank you. Members, any other views? No? Then in this case, we hope that the DOJ will pay attention to this point when you promote arbitration, because we are talking about 2 channels, and we hope that we can try to adhere to the spirit of arbitration. I'd like to thank the admin's representatives for coming. Now I have to ask members the following question. Now, the administration has come up with this proposal. I have to consult the panel's view as to whether you would agree on the administration's proposal to introduce the bill. Any objection to this? No? I think basically you agree that the bill can be introduced into the legislature for deliberation. All right, thank you. And then I want to know if the admin is ready for the following item. Draft live television link, witnesses outside Hong Kong rules, and draft rules of the High Court amendment rules. We are early. The admin's representatives haven't arrived, so why don't we pause for about 10 minutes? So we have a break of 10 minutes.